The Deputy Attorney General of New Jersey argued their case.
Mr. Chief Justice, and may it please the Court, petitioner's factual allegations do not show that the issuance of this subpoena objectively chilled petitioner's First Amendment rights.
Funny that Mr. Iyer claims that a subpoena threatening contempt if First Choice doesn't comply does not chill their rights. I agree. It doesn't chill their First Amendment rights, but it does chill their liberty to retain donors when they find out their personal identifying information has been collected by the state of New Jersey simply for donating to a particular nonprofit organization.
To some of the colloquies this morning about state law, New Jersey state law establishes that subpoenas do not require anyone to produce documents, and a party faces no penalties for non-production. Any legal duty to produce documents, and in this case, any disclosure of donor identities, is instead wholly contingent on a future state court order requiring production.
Interesting. If the laws of the state of New Jersey do not require complying with a subpoena, you would think the Attorney General's office would know that. Yet still, they include this language in the subpoena. Failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided for by law. You have an obligation to retain and continue to maintain the requested documents. Failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided by law. Yes, the subpoena says that First Choice may be liable for contempt of court, but the threat is there. Comply or else. Not to mention the legal cost of First Choice to attempt to quash the subpoena.
This case is a perfect illustration. The state court has repeatedly declined to order production over 2 years of litigation. That helps explain why petitioner never alleged below that anyone actually has been or is objectively likely to be chilled by this subpoena. Instead, at most, the complaint alleges that the subpoena itself, quote, may cause donors to stop contributing. But that contingent language has never been enough for Article 3.
For 2 years, First Choice has had to defend themselves in court against what I will later show to be an unreasonable and therefore unconstitutional search of their records. As for Article 3 standing, as I've already pointed out, since this is a case arising under the Constitution of the United States, Article 3 courts are the only ones with jurisdiction.
The federal government's alternative credible threat of enforcement theory of standing is even worse. State and local governments issue tens of thousands of subpoenas every year. But the federal government's theory would risk turning many of these ordinary subpoena disputes into federal cases, even without a First Amendment claim. That would be a remarkable break from history and tradition.
Perhaps the tens of thousands of subpoenas issued every year by state and local governments, not to mention by federal agencies, should be reviewed. Where do these governments get the legal authority to compel attendance, to deprive someone of their liberty without due process of law? In some cases, to provide evidence without a warrant. That is a violation of the Fourth Amendment's reasonableness clause. It may also be a violation of the Fifth Amendment's self-witness clause.
No court has accepted that theory, and this court should not be the first, particularly in a case where the question presented was itself limited to chill.
While no court may have accepted the theory that a state subpoena violates the First Amendment, well, there's always first. As I said, I believe the court should be the first to consider whether or not subpoenas, specifically language used to compel attendance, violate the Fourth Amendment.